So welcome, everybody. I'm glad you're here. You're going to get a lot of great information today. And if you're joining us on Zoom, hello, hello. So we've got a terrific panel for you. One thing I want to tell you first is how this is going to go. So we're going to start. Each of our panelists are going to introduce themselves kind of briefly. They'll tell you who they are, what kind of thing they specialize in, why what they do is so important to them, and why it's important to you. All right? And after introductions, then I've got a bunch of pre-submitted questions that I'm going to be asking to kind of keep us all in line. And then when I'm done with those, I'll ask for questions from you. So think of your questions, write them down. Don't stop us in the middle, but write them down, and we'll get to them right after the prepared questions. And if you're on Zoom, you can put it in the chat, and your question will get answered too. Okay? We're going to mainly be covering, this is cradle to grave. We're mainly covering the grave part, but there's some cradle in there, you know what I'm saying? So there's going to be a lot of great information. One thing I want to tell you, these people are experts. They're going to give you their best, but this is for information only. This does not create an attorney-client relationship or an attorney-financial planner relationship or a moderator, client relationship. So just know that, and just know they can't know your specific situation. So they can give you their best, but they can't tell you. There's no one size fits all, and they can't tell you in a setting like this. Oh, one thing I almost forgot, turn off anything that buzzes or beeps or burps or whatever would make noise during this. And even though we're all extremely photogenic, no flash photography, please. Okay?
And Heather, who are you?
Oh my gosh. I'm Heather Esthai, and I have absolutely no financial knowledge. So you're in good hands because I'm ignorant, right? First, before they introduce themselves, I want to find out who you are. So how many of you are feeling really iffy about your estate planning and what you've got in place? Like you're just not sure it's okay? Okay. And how many really need to know the basics? It's okay. Okay, good. And how many really have it nailed, you know exactly what you're doing, and you just came for the sandwiches? All righty then, the sandwiches. There's the sandwich group. I think what they'll explain to you as we go along is even though you think you've got it nailed, you may want to review. Okay? So I'm going to start with some introductions. I'm going to start with Gary. And basically, we want to find out who you are. We've seen your bio. We want to find out who's Gary the person, the attorney.
So I guess by the white hair you can tell I've been doing this a while. So I've been an attorney since 1972. I've had my own law practice since 1980, but I'm retiring. So I'm not looking for any business, so if you want any business, you go to Crystal. So somebody who used to work here would start every session with a joke. I'm going to give it a shot. So there's an electrician, and he dies, and he goes up to heaven, and St. Peter says, well, you didn't behave on earth, we're not going to let you into heaven. So he goes down to hell. And he starts improving things. It's pretty hot down there. He sets up some air conditioning. He's an electrician, so he puts lighting in. And so Satan and God were talking, and God says, that sounds pretty handy. I think we maybe can use him up here. And Satan says, no, I'm not going to let you use him. And God says, well, I'll sue you. And Satan says, where are you going to find an attorney in heaven?
Okay.
So you can see I'm not, I don't have any hesitation being critical of attorneys. So I'm going to read a couple things to you that are of interest to me, and you'll see where I'm going when I get there. These are comments on the internet. Do not go to this quack. This guy will be out of business in no time. Those of us, no. This attorney is too old to be practicing law. He was dealt with our family trust, and he has no clue what an Excel file is. He is computer illiterate. Accounting is another one of his major faults. He charges too much for what he delivers, if at all. Why would you go to that attorney? That attorney is me. Neither one of those people were my clients. They were beneficiaries of a trust, and when you have a trust, the attorney is the attorney for the trustee. I'm not the attorney for the beneficiary. I did what what the trustee told me to do, and in fact, one of these commenters, she was a sister of my client, who was her brother, and she tried to take mom before she died to change her trust so that she got everything. So that's the kind of people you sometimes deal with. And I'm sure the Crystals encounter similar things. So everything you read on the internet, not necessarily true. There are documents that you do while you're alive, and those documents then control once you pass away. So it's important, if you want your wishes carried out when you pass away, to make sure you have the proper documents while you're alive. And I'm going to be glad to talk about a lot of those, but there's wills, there's trusts. Minor children is really important. If you have minor children, it's my way of thinking, extremely important that you make sure who you want to raise them if you are no longer alive. But there's powers of attorney for financial matters, powers of attorney, health care, community property agreements. There's a lot to talk about.
Okay. Thank you, Gary. And we will be talking about a lot of that stuff. Yeah. So, Marilyn?
Well, good afternoon, everyone. I hope everyone can hear me okay. I don't feel like I have my full voice, but I hope you hear me okay.
Just keep it close. Keep it close, like an ice cream cone.
Is that better?
Yep.
Okay, good. First of all, I just want to, I am grateful to be here this afternoon to be able to share with everyone about what I do. I am extremely grateful to share the panel with these distinguished professionals. And I want to begin by just telling you a little bit about me, tell you a little bit about what I do for my clients. And I am looking forward to answering any of your questions after we have all shared with you what we do and what we're about. So here we go. My name is Marilyn White. I am a licensed and registered, fully registered FINRA member. FINRA is the Financial Industry Regulatory Authority. And I'm also a registered fiduciary, and that means that I always have to legally act in the best interest of my clients. I'm also a licensed insurance agent with the state of California for 35 years. And I've done additional training and certification to be I am a retirement planning specialist. I've been in the business for over 30 years, and I have joyfully enjoyed my profession. I look at it as a stewardship, if you will. I just feel like what I do is so important in the lives of people and what I do for people, and they let me know it. They always give me feedback, and they really do appreciate what I do. That keeps me energized, that keeps me going. So anyway, I love this Cradle to the Grave title because I think it fits right in with what I do. Many times I will start working with people when they're very young in their lives, and to be on the journey with them through every phase of their financial lives, that is so invigorating to me. And so I don't know who coined this phrase, cradle to grave, but it's very much a part of what I do. I am helping people literally from the cradle to and when I say cradle, I'm talking about the children of the people that I'm assisting. My clientele is very broad-based. I have a lot of high net worth clients. I have a lot of lower net worth clients, and I also have, one extreme to the other. I really get excited when I have young couples come to me who are just getting started and they don't know where to start, but yet and still they're there with a purpose. And I'm just glad that I can be there for them and be I guess you could say, a guide for them in terms of how they're beginning their financial lives. I work with everybody. I work with women. I work with men. I work with small and medium-sized businesses. And yes, I even work with churches, believe it or not. Oftentimes people are sitting on the fence because they don't know where to begin. And I don't know if any of you fall into that category or not, but I have been very instrumental in, kind of easing the discomfort around where do I begin, where do I start. And so, I help them, I sit down and I help them to identify their goals, their objectives, whatever it is that they would hope to accomplish. And maybe they're just ready to buy that first home. Maybe they're ready to just start a family. Or maybe they just want to learn about investing. Or they want to, invest for retirement. Or they just want to invest because they want to build this significant nest egg. And yes, I have created quite a few millionaires along the way. And I'm not going to go on and on, but there's one other thing, let's see. One thing that I want to say is that when I meet with clients for the first time, that is probably the most critical and the most important step in the process, because in that process, I have a due diligence that I have to do, and I step into that role as a financial advisor, as a fiduciary, in my capacity to just guide them and inform them. In that first meeting, I am, what's the best word to use? I must begin by listening to everything that they have to tell me about their circumstances and themselves, because it's very important that I listen to them, but by the same token, this is an opportunity for me as the fiduciary, as the financial advisor, to obtain all the information that I need from them so that I know that I, have fully, establish a profile for them in terms of how I should proceed for them. And so I will ask, I'll ask them things like, well, what is your age? What is your net worth? What is your income? What are your current assets? How do you feel about the market? How do you feel about risk, et cetera, et cetera? And so it's necessary that I gather all of that information so that I can have that profile to work with them. I think one thing that I wanted to say is I do get very involved in estate planning. I would say about 75% of my clients already have their estate plans in place. I just think that is so important because now, let me just state this. In that financial estate planning process, there are certain vehicles that are already kind of self-contained estate planning vehicles, like annuities, retirement plans, pensions. Those are already self-contained, if you will, estate planning vehicles, because at the time that you set those up, you name the beneficiaries. So if something should happen and you're not around anymore, then those assets just pass very easily to the beneficiaries. Now, other assets, which Gary and I'm sure, Crystal, I'm often referring many of my clients to the Garys and the Crystals of the world, because I do get very involved in the estate planning process, but when when it's time to draw up those legal documents, these are the individuals that you're going to be turning to do that. So I will stop and let somebody else talk.
Crystal.
Okay. Thank you. I look forward to answering your questions.
Thank you. Good afternoon, everyone. My name is Crystal Carpino. I also want to say that I am grateful to be here today to answer your questions and to talk to you about the importance of estate planning. A little bit about myself and tell you where I come from, and sort of so you can know what motivates me and why I've done what I've done in my life and why I do what I do in my life. I'm from Oakland, California. I was born and raised there. I went to college. I went to Harvard and graduated, and then I moved back to Oakland, where I began to pursue a career in the medical field. I was really passionate about being a doctor. So I did medical research for a little while. And then I embarked upon a series of other careers and trying to figure out, where my passions and desires were going to lead me. And I did a number of different things. But then after my 20s passed by, I realized I should go back to school and start being serious about my life again. And I decided to go to law school. So I went to law school at UC Hastings in San Francisco, and I went specifically to be a public defender. I always, from the time that I was a kid, was focused on some type of helping people. What that would manifest into would change throughout my life and probably will continue to change throughout my life. But being of service, helping people who are less fortunate than me, especially people who are not economically fortunate and people of color who often get the shortest end of the stick in our society, those were the people that I was drawn to helping. And so I went to law school with a singular focus, which was to be a public defender. And I put everything I had into becoming the best, working for the best office. And I was a public defender for about 10 years. And I worked in San Francisco. And it was the best. I learned so much about myself, about other people, about the world. I learned how to harness my own strengths. I learned how to use my voice for other people. I learned how to be tough. I learned how to stand up and literally be the only person fighting for the person who's sitting next to me, the only one. And how difficult that is to stand up alone against a system of judges and prosecutors who are there with the power of the government, with all the resource of the government behind them, and just me, literally, standing up. So that's what I did for 10 years with my career. It was absolutely the pleasure of my life. I'm sure there will be more. I mean, I have a daughter, and she's the pleasure of my life, too. But, career-wise, there's just nothing I would have traded it for, all the things that I learned. But the other side of that career is that I absorbed so much stress and trauma from my clients and from the stories that I had to take on. And there's a price that you pay for being so close to trauma and being so close to tragedy. And it's something that I probably would have been able to continue had I not had a family and had I not realized that I needed to be more present for my family. And so I, things that you see, they get into your head and they just sort of stick there. And they inform the way you parent, the way you engage with your partner, with your friends, with your community. And so I really was very intentional about thinking about the next phase of my legal career and what I wanted to do with that. And as I explored other options and because I'll back up and say to you, when I became a public defender, I said, if I'm not going to be a public defender anymore, I'm not going to be a lawyer. That was the only thing that I really wanted to do. But I said, I've got this legal degree, this law degree that I paid a lot of money for, that I spent a lot of time getting. So I really explored, and I landed on estate planning because of that ability to help people and to help them set up their lives for their children, to have peace of mind, to help you grow, and to help you be more peaceful about what's going to happen after you go, after you pass, after you die. I say, I don't want to offend anyone if I use language that offends you about death. We talk about death a lot in our industry, but that's why I do it, and you hear a lot of people these days talking about generational wealth and how important that is to a lot of families, especially how important that is to minority families in the community, people of color who don't, and other groups who don't necessarily have that deep generational connection. A lot of people in the United States were cut off from developing and from owning property, from being able to have things to pass on to their children. So that's what really motivates me. And I find that in my career as an estate planner, I can fulfill that same desire and that same goal for me, which is to help people. And I think that that's one of the most important skills in being a lawyer, period, is being able to talk to people and being able to, glean what they need, relate to them, just look somebody in the eye and let them know that you take their situation seriously and that you really care. Let's see. So anyway, I guess we'll get into the meats and bones of what we actually do, but that's a little bit about myself, so thank you so much.
Okay. Yep. Marcia?
Thank you. I'm Marcia McCrimmons, and I am very happy to be here, honored to be here with all of you. And as somebody who grew up in a family of 6 children, mostly raised by a single mom, I kind of realized the challenges faced of trying to just make a dollar stretch just for basic living needs. And I always, as a child, wanted to go into something where I helped people. And so I decided that I wanted to be a nurse. I went into nursing, and through that, I've worked through pediatric nursing most of my career, and I realized the challenges that people face, families face in their lives. And I could relate to it. We would have families come in, doctor would tell them medicine to get, and they said, I can't afford that. Or they'd come to the office asking for extra formula because they can't feed the babies. And it really struck me. And so one day I had somebody come to me and ask me about my own finances. And I said, I don't really have anything in place. I was young still and didn't really think about it. And so they did a financial needs analysis and kind of showed me my shortcomings and shortfalls and all that stuff. And so I decided that I wanted to work with them too, and I figured I could kind of do both things, help people physically and financially with their health. And so that's what I did. And I still work, I do mostly do financial services now, but I still keep my toes in at the pediatric office, taking care of the patients. And so what we do is we offer people financial needs analysis. It's a completely complimentary, confidential report that we run for people. They can list all of their, assets, liabilities, debt. It creates a whole solution for them it's kind of like a GPS for their life too. When you get in a car and you want to go to somebody's address, well, this just gives you your financial GPS and where you're headed. And when people come, I just I tell them to, leave blame and challenges at the door. I just recognize and respect everybody's attitudes toward money, and we just kind of create a financial game plan for them to where they want to be and when they want to retire, college funds. We do all of that stuff, and I work here with Tony, and so I'm going to pass it off to him.
Thank you, Marcia. Hey, I appreciate everyone having me for this afternoon, I guess. My name is Tony Lay, and just as Marcia has explained, I'm grateful that you invited me to come out here to be able to share my part, if you will. Kind of like what Marilyn shared, I'm licensed as well, too, in the investment side of things. I kind of got started really just understanding that it's culture. As you guys see, I'm Chinese, right? And at a very young age, how do you say, I always noticed that there's certain things we weren't doing. From a cultural standpoint, we didn't really talk about money, family itself. We talked about certain things like saving and, don't spend what you don't have, but it wasn't really about investing, And so I myself, 18 years old, 19 years old, got off to college and just kind of got started. Went out in the world, learned myself. Back then, the internet wasn't like what it was today, if you will, So I found out some information, got myself started, and essentially, I fast forward, put some money in, didn't really know what was going on, and realistically, a client of mine kind of came to me and said, hey, there's a company, this is kind of what I do in terms of finances. I was like, yeah, this sounds great. And I kind of got started myself. So I started to learn, what this was, how we help people, and I really got stuck with the investment side of things. And so fast forward, now every single day we meet people, families, individuals. We help you guys say cradle to grave, really it's 529 college savings funds and uniform transfer minors, accounts for young kids, children, babies, things like that. And then even smaller accounts for savings. We have accounts for short term, hey, I'm trying to buy a car, trying to save some money, buy a house. And then obviously the long term, kind of what we're here for today, the wealth building accounts. So we have these retirement accounts that most everyone needs, We all want to get to a spot where essentially we don't want to work, we physically can't work, or mentally don't want to work as well, and get to a spot where we can actually retire, So we work with everything in between. Marcia shared most of that. Through the financial needs analysis, we're able to capture a lot of information, find out where you guys are at, and then pinpoint your goals. So we actually know where you're looking for, and we really are the navigators. You guys are the pilots, if you will. We just identify where you're at, find out the destination, and we do our best to try to help you get there. So thank you guys for having me. Let's hear some questions.
Great. Okay. So go ahead and applaud. Okay, I'm going to ask some questions, and I'm going to ask them to one of you. However, after that person's finished, if you have some things to add, go ahead and add. But if you'll kind of stick to what I'm asking, rather than traveling off on the road untraveled, that would be helpful, because we're trying to cover a lot of territory. Is that fair? And I'm going to lean kind of heavily on our two attorneys initially, because we'll be talking about sort of documentation and those types of things. So I'm going to start with you, Crystal. And if you could, for people who don't really know what estate planning is, could you give us kind of an overview and tell us the components of it? And then if you could, write it down. Then if you could, we hear the words will and trust, and some of us know the difference and some of us don't. But if you could talk about the differences and maybe some pros and cons.
Okay.
And then I know the rest of you are going to want to jump in on that.
Okay, so what is estate planning as an overview? So we all, I think, have an idea about what we would want to happen to our stuff after we die. And I'm just going to say stuff to encompass all of the things that you have, whether it be real estate or, a valuable collection of coins, for example. And so what an estate plan is an opportunity for you to document for the people who will come after you what you want to do with your stuff. It's your opportunity, it's your one opportunity to quote unquote legislate from the grave, and have your wishes and your intents be honored by the people who come after you. The other part of an estate plan is to simplify that process for the people who are going to wind up your estate as well. So, how many people have heard of probate court? Right. And is probate court a fun place to be? No. And so your estate plan is going to keep your heirs, the people who wind up your estate plan, first and foremost, is going to help keep your estate out of probate. Probate is a court where they handle people's estates for people who have not made an estate plan or whose estate plans have failed them. So it's important to also realize that even if you have an estate plan or part of an estate plan, if you haven't, I will say this, if you haven't consulted with an attorney and had an attorney do this estate planning for you, and if you've done it and you haven't updated it over the course of your life as things change, as you acquire property, as your net worth changes, fluctuates up and down, there might be unintended consequences after you die, and your estate might end up troubled, even if you did try to plan for it, but you didn't do it right or you didn't update it appropriately. The other part of an estate plan that I think a lot of people don't necessarily think about is that part of estate planning will assist you while you're still alive and will provide guidance for your trusted family members and friends to deal with your stuff if you're alive but incapacitated as a result of accident or an unfortunate medical incident. So an estate plan will give you documents like an advanced healthcare directive, which is basically a power of attorney for your healthcare matters. You can appoint someone to be able to see your medical records and to be able to make decisions about your health care if you don't have the ability to make those decisions on your own. And you can also talk about in your estate plan how you want to be cared for if you're in a coma, literally down to every single detail, how you'd like to be dressed, if you'd like to be forced to consume water or food. And these are things that you might not necessarily think about, but if they're important to you on a spiritual level or on a practical level, no one's going to know unless you write them down in a place where people have access to. So an estate plan will also protect against unintended consequences. A lot of people think, I don't have much, and I've dealt with my assets with other types of transfers that might transfer your bank account or use a beneficiary to transfer your assets, and you might think you have that all taken care of, but there could be an unintended consequence to all of those things, and I can get in, to some examples later. So the components of an estate plan generally are a trust, a will, your maybe a marital property agreement if you come into the estate plan as a married couple. You could plan for business succession, and then you will also get the advanced healthcare documentation, a durable power of attorney, which is also an important document. You can appoint someone as your agent to deal with your financial affairs if, again, you're incapacitated, or if suddenly you're struggling with a diagnosis of early onset dementia or Alzheimer's or memory loss, and all of a sudden sometimes you're able to make your own decisions and sometimes you're not. So you want to make sure that all of this stuff is in order before stuff hits the fan.
Before you kick the bucket.
Yeah.
Yeah.
Sorry.
And fall apart. Yeah. We get it. We get it.
Yeah. So let's see. Will versus a trust. So that's a good question, right? So A modern estate plan is going to give you both, but only the trust will keep you out of probate. So if you have a will only, you have to know that that will not protect your estate from probate. Only a trust, a revocable living trust, will keep your estate, or a trust will keep your estate out of probate. I think wills are, they're in terms of like making beneficiary designations, that's not where you're going to make, if you have an estate plan, that's not where you're really going to make your beneficiary designations too much anymore. The trust is going to do the heavy lifting for your estate. The trust is going to talk about what you have and who you want to give it to. And it can be as simple as it needs to be, and trusts can get as complicated as they need to be, depending on your financial situation. And so a will in most estate plans is going to be what's called a pour-over will. And a pour-over will does almost literally exactly what it sounds like. If you have established a trust and you've unintentionally left out some property from your trust, the pour-over will come and clean it up for you. So the pour-over will literally pour over that asset into your trust. It will make it easier for your heirs or your successor trustee to manage your estate if you have the pour-over will. And if you get a full estate plan, all of those things are going to come together. And the attorney that you consult with is going to talk to you about how those two documents work together. So, in my opinion, it's not a question of which one should you have. You should have both. You need to have both. They work together. And as long as you're talking about a trust and a will, you might as well get the whole estate plan together, because you do need the durable power of attorney. You do need the advanced health care directive. And for people with children who are minors, like was said earlier, the estate plan is going to allow you to choose who you want to raise your children if you die. And we don't want to think about these things happening, but they do happen. You know, parents go out and get in a fatal car accident. It does happen. So you want to plan for those things, and you can say, I want these people to raise my children. So, yeah.
I would just add that you're designating somebody who can sign for you. If you're passed away or you're dead, you can't sign anything, and somebody has to do that. So the probate court appoints somebody to sign and become responsible for your assets. And when you have a trust, you're designating a successor trustee who can sign and step into your shoes. The other important thing, I think, Krista would agree, is the court doesn't know you, doesn't know what you want, but your documents are telling the court, if you end up in court, and some trusts end up in court, and all wills end up in court, but the court's duty is to carry out your wishes and know your intent, and they won't know that unless you express it. So Krista used the word durable power of attorney. Durable merely means that it's still in effect if you become incapacitated.
Anybody else got a, okay. Gary, actually the next question's for you. Put that mic, you pick it up. So, you just talked about this. You talked a little bit about somebody like the successor trustee will be taking over. And I know I've served in that capacity now a couple times, and there are a lot of responsibilities with it. So if you could just talk about some of the responsibilities of a successor trustee, and also what kind of person would you choose for it? And would it be a family member? Would it be a professional? I mean, just give us some input on that. But first, what are the general duties and responsibilities?
Well, what the successor trustee is doing, and it's the same for an executor of a will, they're basically liquidating and consolidating your assets so they can be distributed according to your wishes. It's as simple as that, but there's a lot of work involved sometimes. It depends on what assets somebody has and how hard it is to liquidate and consolidate. An example of who should be a trustee, I have a client a husband and wife, and they have 2 daughters. One daughter is a nurse and one daughter is a financial planner. Well, the financial planner is not compassionate, and they don't want her in charge of making medical decisions. So she's not the one who's named in the power of attorney for health care. The other daughter is the successor trustee of their trust, and as Crystal explained, the pour-over will works with a trust in conjunction with a trust. And so she, the financial daughter, is the one who's in charge of carrying out the wishes financially. And hopefully they can work together. But and I think Crystal will probably agree, attorneys make their money because kids don't agree. Kids want to fight, and kids are sometimes greedy. And if everybody got along, we wouldn't make any money. But I do want to add one thing. Crystal says that she was a public defender, and just so she knows, I was a prosecutor.
Oh, scary, scary. So basically, are you saying that a successor trustee should not necessarily be family, or if they look at their kids and they think, this is never going to happen, who do they go to? Who can be another trustee for them?
Well, 99% of the time it's family, but in other cases, it's like Marilyn said, a fiduciary. There are private fiduciaries that they make a living and get paid to step into your shoes and, again, liquidate your assets and consolidate them. So sometimes it's, I can only think of once when I became a successor trustee of a trust. To me, it's a conflict of interest, and I don't want to do that. But usually it's family members. Sometimes it's very close friends, and sometimes when they don't want to have family be involved because they know there's going to be a problem, hiring a fiduciary who gets paid, and they can tell the hourly rate, but they know what to do, they know how to do it because they've done it before, and they're very efficient at doing it, but they're going to get a fee for doing it.
Okay. Anybody else want to? Yep.
Can I just make some comments around that? Clients, of course, they die. They do. And when that happens, of course, if it's a trust account, it is interesting to see how some of those scenarios play out after the client passes away. In my own personal situation, in terms of, deceased clients, most of them, I have to say, have been family members. At one point, a very dear friend of mine even had me listed as as one of the successor trustees. And I finally had to get that removed because there's so many strict guidelines around the financial industry now. And so, and even though she was a very dear friend of mine, there are laws now that have been passed that precludes us from, unless it's a family member. In this case, this person was not a family member. She was just a very dear friend. But anyway, I just thought I'd let them know.
Yeah. Okay, let me ask Marilyn to pick up the mic again. So you mentioned something about self-contained estate vehicles.
Yes.
That didn't have to do with the trust and didn't have to do with a will or a pour-over will. Can you talk about those vehicles a little bit?
Yes. Typically, when you set up, take out a life insurance policy or an annuity, or even when you, if you're working and you have pension plans, 401ks, IRAs, those type plans, you always list beneficiaries on those. And so they do not, usually they're not a part of your trust. They can be, but usually they're not. So if something should happen, then those assets pass directly on to the named beneficiaries on those documents when the account was set up.
Okay.
Simple. No probate. No dreadful probate. Keeps it simple.
Okay. Good.
Can I add something?
Yes.
Real quick? Thank you.
So I think it's important, my main point here, I think, is that because of some of the things that have just been brought up, I want to say it's really important in this process when you're talking about estate planning to actually consult an attorney and to not do this stuff yourself. There's a lot of what? Was that a question?
We've got something going on. No. Go ahead.
did tell me not to divert from the question.
Go for it. Go for it. Go for it. We'll tell our story in a minute. Yeah. No, go ahead.
No, it's just important because some of these accounts you might not know, and you might get conflicting information from different people who are not attorneys and tax professionals and financial planning professionals. You might not always hear the same thing about what you should do with a certain type of asset. So, we can sit up here and generalize about this type of account usually shouldn't go into a trust and this should. You really want to consult with your professional to make sure that those designations are proper, because you really, for example, if you put some type of retirement account into your trust, your heirs or your beneficiaries could really take a hit on taxes. So you want to just make sure that you're doing all of this stuff with a professional. That's all. I know that was a question.
That's okay. That was a good one.
Clarify that retirement accounts do not go in a trust, but retirement accounts could be a beneficiary of a trust. What Crystal just said is extremely important. You should not make a trust the beneficiary of a trust for tax reasons, or at least consult with a financial advisor before you do that.
Could you say that again? You should not make a trust in the. Say it again. Say it again.
Well, retirement accounts cannot be owned by a trust.
Okay.
And retirement accounts should not be a beneficiary of a trust because of tax consequences. If you end up doing that, and sometimes we'll do a retirement account to one individual, another individual, and then do their trust as in the last position, that's possible and it's okay, but I don't recommend it. And before you name a trust a beneficiary of a retirement account, you need to consult with a financial planner.
Does it include a Roth account? Any type of retirement account? So again, we've hit something that's kind of technical, and you all probably have different types of retirement accounts or none. So that's when you want to consult. That's when these guys can't really answer it for you because they don't know your specific situation. They can answer it generally, but not specifically. But that brings me to another kind of technical question. There are a bunch of assets that you have, or a few assets that you have. What of those assets need to be titled in, you need to put the title into the trust? Like your house has to belong to the Brian and Grace Stevens Family Trust kind of thing. What assets need to do that?
Sure. So generally speaking, your primary residence, if you own your home, should definitely be in your trust. These are things, so let me start from the beginning. In order for a trust to exist and work, it has to have something in it. So if you think about a trust as a basket, if the basket is empty, the basket just won't hold water. So that's another thing that a lot of folks might mess up if they do it themselves or don't consult the right professionals, is that if the trust does not get funded, it's pretty useless. So one of the first things if you own a home, is to put your home in the trust. That will ensure that the trust is in existence, and that it will hold on to your primary residence. Other things you can put in your trust right away are your primary bank accounts, your investment brokerage accounts, and things like that. Now, when you establish your trust, you're going to talk to your attorney and your professionals about what's called a Schedule A, and that is a document. It's an addendum that comes at the end of your trust, and it literally lists the assets that you intend to put into your trust. So usually the first thing is your home, and then you'll put on that Schedule A all of the other assets that you've decided with your attorney that should go into the trust. So like I said, basic financial instruments, bank accounts, savings accounts, high yield savings account, brokerage accounts, things like that. When it gets a little bit more complicated, like the retirement accounts, we don't want to put into your trust. They're going to stay outside and pass by their beneficiary designations. Life insurance also. Other than that, your personal property, you can list on there all the things that you have of value. Like I said, your collections, your personal effects, and things like that. You can put your business. If you own a business, you can assign your business to the trust. Although things like that do get a little bit complicated, right? So that's when you're going to want to, again, have your meeting with your attorney and decide if it's beneficial to put those assets into your trust. You can also pour assets into your trust on at your death. So you can arrange for the asset to sort of transfer to your trust automatically at your death if that works. But these are all things that you would talk about with your attorney. Anything to add?
No. So I'm going to go to the other end of the table because it's been kind of quiet over there. I know because we've been getting into really the legalese of the whole thing. But Tony, let me ask you. I know a lot of people either have children or they have grandchildren, and they're concerned about their financial future. You know, if they kick the bucket, as we say, what happens to those kids? And what are some of the vehicles that you know of, Tony, that are helpful for people that even if they die, this will help maybe fund education or keep them solvent or whatever? Just think of that. Yeah.
Yeah, of course. Yeah. So usually, like Heather was saying, if somebody passes away, beneficiaries sometimes, typically you don't want the minors because you basically it goes through a lot of steps before you actually be able to receive the money. Right. So putting beneficiaries as adult children would be best, but when you guys do that, what happens is that they're going to inherit the accounts, right? So we have to start new accounts depending on what they qualify for, if you will. If they're working, they have earned income, that money can go into qualified retirement accounts such as traditional IRAs, Roth IRAs. If they're not working, you go into just regular non-qualified. I know it sounds bad, but just regular investment accounts. Don't really have tax advantages, but they can go in there, and obviously you can speak to financial professionals like myself, Marilyn, and we would go over exactly kind of what to invest in, if you will, in the proper investment vehicles, and basically help them grow that account. So.
Well, thinking more of like kids,
Okay.
not adult children, but grandkids or kids where they're not even out of school yet. They, a 5-year-old can't open an account. What kind of vehicles are there for parents and grandparents? Yeah,
so for parents, grandparents, we talked about a little bit before, 529 college savings funds. You have uniform transfer to minor or uniform gift to minor type of accounts. Basically, a custodian, a parent, adult, someone who's 18 years old at least, right, would open some of these accounts for these minors. And they can open these basically to help, once again, either fund for college, so these college accounts, they qualify, meaning they have tax incentives. They grow all tax deferred, meaning as for example, you put in $1,000, it has some gains, no tax on any of the gains, and then later on when you use it for college expenses, tuition, books, it's all tax-free, right? That's wonderful. And then also, if you just want to save some money, help them invest, you guys put into uniform transfer to minor, uniform gift to minor type of type of accounts. And when that happens, basically the money grows. There are some tax savings. I'm not going to get to the technical aspects of it, but it reaches a certain point. Usually at this time, it changes every single year, but about a couple $1,000s in earned income, if you will, before they start taxing you. And then this money, unlike the 529 college savings, you can use it for whatever you want. Buy a car, books, tuition if you want, things like that, but you're not going to get penalized if you don't use it for college, just like the 529s will.
So when somebody sets up one of those accounts and they kick the bucket does it automatically somehow get to that child or their guardian?
Yes. So let's say a person sets it up, like grandparents or parents. They set it up. You can name successor custodians. At any point, I hate to say this, but if there are no successor custodians, it'd be court ordered, and then a guardian can take over and continue to work with, once again, the person who set it up as a financial professional to continue those accounts for them as a legal guardian. So.
Okay. Okay, good. Anybody want to weigh in on that?
I'm sorry. Go ahead. No, I was just going to say I agree with everything that he said. I just had a situation recently where I set up a 529 plan for a grandchild, and of course the grandmother was the custodian that set it up. And so grandmother passed away, and she didn't do it initially. She didn't name the successor initially, but as she started to ail in her health, she came back and she named her son as the successor custodian. So that 529 plan is done, but that happens. Yeah, it just happens.
Okay. So if you're going to do that kind of thing, you need to name a successor guardian.
There was
Probably.
a time. Now I think that all of the firms out there, they have the provision with the systems, putting these things in place where you can name a successor custodian. In the old days, they didn't, but now they do.
Now they
so
do.
That's good.
Okay.
Yeah.
Okay, so kind of moving, we've talked some about assets, and I want to talk about debt because I had this situation when I was trustee for my mom. I'm sorry, you're pointing? You know what? We're going to take questions in a few minutes. Yeah, thank you. So I was the trustee for my mom's estate, and unbeknownst to her, she had built up quite a bit of credit card debt. So I ended up having to handle a bunch of credit card debt. Now, I know none of us want to die with a lot of debt and leave it for others, but I want to mention to Marcia, have her answer this. So there, we always talk about debt, and you go online, they have all these strategies for getting out of debt and da-da-da-da-da. So in your mind, what are some of the best strategies for avoiding debt and certainly not leaving this planet with a bunch of debt?
So what we offer is a debt stacking solution in our financial needs analysis. So it pretty much helps people to kind of take their debt in order. It's a totally computer generated system, and it just kind of, what it'll do is after this one's paid off, they use the same amount of money they're spending and put it toward the next debt, so that it gives them kind of a game plan for getting it paid off. I mean, it just, as of the end of 2025, credit card debt in the United States reached $3.3 trillion. So it's a real problem out there that people need help to understand. And even when people are given, a raise, it's the education they need, not the raise, because people will just spend according to their means. If they have a little bit more, well, I can buy a little bit more. And it's really an educational thing. People need to be educated on how to stop getting into debt or accumulating more debt and then, paying off what they have.
Okay. So when somebody does die with a lot of debt, and this is kind of a legal question, what is the responsibility of the estate? I mean, does the estate have to pay those debts off or not? Should we record this or maybe don't? I don't know.
The answer is yes, the estate does have to pay the debts. There's some debts that die with you, but most of the types of debts that we're talking about, credit card debt, if you owe any back taxes, the government is coming for their money, and things like that. So yeah, that's the first thing that gets paid out of the estate is the debts, and all of the creditors get addressed, and that is the job of your trustee. Not only are they tasked with gathering up your assets, and it's technically called marshaling the assets. You gather them up and figure out what they are, and you total them up, and then the first thing you do with those assets is pay the debts. So, yeah.
but the trustee is not personally liable or responsible for those debts.
Okay, anybody want to add to that? Okay, I'm going to open it up now. Oh,
I'm going to say a couple things that are just pointers to me, and it'll answer some of your questions. So if you have nothing and you want to do a statutory will, it's fill in the blank. It's in the California Code, very simple, and then you have a will. You do not need to go to an attorney to do that. I would recommend, if you have the possibility to do that, you have it reviewed by an attorney, but a statutory will is just as good as a valid will. A holographic will is a handwritten will in your handwriting, dated and signed. It is just as valid as a will from an attorney. Secondly, irreversible trust and, irrevocable trust versus revocable. I do not recommend, unless under special circumstances, you try and do an irrevocable trust because you lose control. With a revocable trust, you can change it as long as you're competent your entire life. Should you have one or two trustees, I highly recommend you have one trustee and then an alternate and then an alternate. The reason being, I've had a case where mom had a trust. She had two children, a son and a daughter. They didn't like each other growing up, and they certainly didn't like each other after mom died. And they ended up paying me $40,000 to fight over nothing. Not worth it. So I recommend, and Crystal can chime in, but I recommend one trustee as opposed to two. Sometimes I will do two, especially if that's what the client wants. Or you do a trust and the pour over will and a power of attorney for financial matters. You're naming a successor trustee, you're naming an executor of the will, and you're naming an agent under the power of attorney for financial matters. Those three documents need to have the same order of priority, the same first choice, second choice, third choice. Otherwise, you have the possibility of having great conflict while you're alive. And the example is if you get dementia. Say that again. You have a trust that names a trustee and a successor trustee. You have a will that names an executor, and you have a power of attorney for financial matters that names an agent. All three of those should have the same first choice, second choice, third choice. The other thing that I would add is that the probate code, either in your will or in your trust, can put in a provision. Some people say, well, I want to leave my bracelet to my nephew. He wears bracelets, I don't know. And then you change your mind 2 years later. Do I have to redo the will? So there's a provision in the probate code in California that you can have an external writing, not your will, not your trust, where you say, I want my earrings to go here, I want my bracelet to go here, I want my necklace to go there. And the code says each item has to be $5,000 or less, and the cumulative value of those assets should not be more than $25,000. A year later, you change your mind, you want the bracelet to go to somebody else, you just tear up that piece of paper and write a new one, and that piece of paper should be dated and signed, but you don't have to redo your trust or your will. That's just it's not it does not have a name, but it's probate code 6132. Another thing I'll touch on, this, and I may be stepping on some toes, but that's okay, I'm known for that. This church may not be here, but for someone who was with this church leaving it some money when they were in dire straits. And so if you have an opportunity and you have the desire, you can make a world of difference to this church or any other charity that you choose to donate to. So consult with your attorney, and your attorney will know how to do that. In the California, the probate code has a language for a power of attorney for financial matters. When you have a trust, and I don't know, not all attorneys know this. I learned the hard way. You need to have two powers of attorney for financial matters. Why two? Well, let's assume you're in the hospital in a coma and you have a power of attorney for financial matters as an individual. You've named someone to make decisions for you financially because you're in a coma, can't do it. That has something to do with, say, for example, health care. Health care has nothing to do with your trust. Health care is you as an individual. So in a like manner, let's assume that your house is in your trust and the Sacramento County assessor doubles your real property taxes, that's not you as an individual. And the governmental agency may not recognize that power of attorney you signed as an individual. So you sign an identical one, a second power of attorney for financial matters that you sign as the owner and manager of your trust. So that one deals with trust assets, the other one deals with individual issues. The other thing, the importance of power of attorney for healthcare. Terry Schiavo. Terry Schiavo is a young woman who had a cardiac arrest at age 26 in 1990. Some of you may remember that this was in the news and the courts were fighting over it for years. She was married, and in 1998, again, she goes into a coma in 1990. She's put on a ventilator. 1998, 8 years later, her husband says, I want to take her off the ventilator. She's not alive. He goes to court to do that because she did not have a power of attorney for health care. Goes to the court says, all right, take her off the ventilator. Her parents disagreed, says she's still alive, and they put her back on the ventilator. That's 1990 to 1998. 2001, the court again issued an order to take her off a ventilator. And it was reversed again 6 months later by another court. This even went to the United States Congress over this poor woman, whether she was alive or dead. Finally, in 2005, she dies. They take her off the ventilator. She'd been dead for 15 years. You must have a power of attorney for health care. It is that important. And all you're doing is, as long as you are capable, you make your own health care decisions. It's when you're incompetent or incapable in a coma or whatever that you're designating somebody to make those choices for you. Lastly, estate tax, which we haven't talked about. You don't need to worry about a federal estate tax return. There is no inheritance tax return in California. By 1982, I think the initiative passed, so there's no estate taxes paid in California, but there's still a federal estate tax. And for those of you that have $15 million, there is a federal estate tax, and you should consult with an attorney.
Okay, good. Crystal, you.
Oh, I was just going to say, if you do elect to do your own will, you still have to have two witnesses. So, yeah, that's just if you elect to do that on your own, you do have to have two witnesses sign a will and a will codicil. The other thing that I'm reminded of that some people have also learned the hard way is that if you have a trust and a will and you decide to change your beneficiary designations on your own, or if you want to change something, again, consult your attorney, because a will codicil will not change your trust. You have to have a specific type of amendment to change your trust, and a will codicil just means like amendment. It will not amend your trust. So, again, another.
So in California, wills cannot be notarized to be legal. They must be witnessed by two people. And the other thing about the power of attorney for financial matters, you can have it notarized or you can have it witnessed. I highly recommend you have it notarized, because then it would be honored by a title company if real estate is involved.
And they're more likely to accept notarized documents in hospitals as well. So for your medical documents, you also want to have those notarized.
Okay. This has been a heck of a lot of information. We were hoping to get more into some of the basics, more the cradle side of financial planning, but let's stick with the estate for now, And people have questions. Okay, Claudia?
You talked about the kinds of accounts to assign beneficiaries to. Can you talk about pre-tax accounts and the liability of the beneficiaries?
So she's talking about
a distribution schedule for pre-tax accounts?
If it's an investment or retirement
Are
account?
you talking about tax-deferred accounts?
Yes.
Is that what you're talking about?
Yes.
Well, it depends on who the beneficiaries are, because if it is a spouse there's a certain, rules around that. If it is a non-spouse, then there are certain rules around that. So for a spouse, let's say it's a retirement account, and let's say, the husband or the wife inherits those assets. If the spouse had already begun to, take their required minimum distributions from that account, then the spouse can continue that same, distribution frequency. With non-spouses, there's a 10-year time frame around when all the assets must be distributed completely out of that account.
Okay. Over there. And do we lost Lisa. Do we have some questions from the chat? Okay.
Me? Ready? I did a deed upon death for my house. Does it still need to be listed in the trust? Okay.
Gary, microphone.
So in California, you can have your property owned as joint tenants. When you own it as transfer on death deed, it's the same thing. It's an automatic. It transfers by operation of law. Correct?
Correct. But
Microphone.
Did you have?
are you? Is the question that you're asking? Is it good enough to have a transfer on death deed on your house so that you don't have to have a trust and a will, or?
No, I just did it because it's my son. So the minute I die, he becomes the owner of the house. It wasn't even about tax. And in fact, I didn't even think about the tax repercussions or the property. I have Prop 13. So I didn't even think about that. I just thought it would simplify his life. He has no siblings. I'm not married. Don't plan to do that again. And so I thought it would just simplify his life. When it came to the estate, he wouldn't have to worry about anything except paying, insurance and taxes and all that on the house, and he would then be the owner.
So the transfer on death deeds have a special requirements when you pass away as to what your son has to do. So I would highly recommend that he speak with an attorney, even though it's a transfer that can be recorded with the county recorder. There's notice that's required. There's other requirements in the law as to what has to happen to successfully effect that transfer. But there's nothing wrong with the transfer on death deed.
Okay, but then you don't need to separately list it in a trust. If it's,
Then you know what?
you don't need to separately list it in a trust.
Correct.
Okay, and all of the financial accounts I have, he's already beneficiary, but I should still list those in a trust?
Yes, because if he doesn't outlive you, you want to have him going somewhere.
Because what?
If he doesn't outlive you, if your son dies before you do,
Yeah.
you want your assets to go someplace.
Okay,
That's
if
what
he
he's
dies
saying.
before me?
Well, yeah. So, and this brings up another point that I was going to talk about a little bit is when you rely, I call those things non-probate transfers. So because they will transfer outside of probate, your bank account will transfer outside of probate, but you really that's your only control over it. Does that make sense? Like if you and you only want to do one or the other. So either your bank account is going to have your son as a beneficiary, or you're going to put it in your trust, and the trust will deal with who the beneficiary is and what percentages your estate is going to be allocated in. So I think the trust and will in your estate plan gives you a more centralized opportunity to focus on your assets. If you have everything taken care of, it's okay, but I think you just have more centralized control if you have all of those decisions made with the trust and the will, if that makes sense. Yeah.
Well, like the bank account, he owns it as much as I do. He's on
And that's, yeah.
It's not a beneficiary, he's just owner of it.
Okay.
Yeah, and yeah, I mean, it does happen. What if you outlive your child, And so, and then what if something happens to you before you get a chance to change it, then, you know, it goes to the last person or the last entity. Okay. Well, you know, for situations like this, I think it's beneficial if you want to talk about this and decide what, you know, what's good, what might be better. Schedule a consultation with an attorney. Like for me, we do 30-minute free consultations at my firm. So you could call me and I could go over your documents, you know, for a few minutes before our consultation, and we could talk about whether or not it's, yeah. But no, it's a good question though. There are transfers that can go outside of probate and they do the job just as well.
Okay, did you have there's one in the back. Uh-huh.
Hi. So I have a trust. My home is in the trust. I've heard conflicting opinions. Should I put my vehicles in the trust? Yay or no?
Gary says no.
I say no.
That's a personal decision, and each attorney will do it differently. The reason I say no is that you die and your vehicle's there, and whoever's going to get it is going to have to go to DMV and sign something under penalty of perjury, and your vehicles come and go every 5 years or whatever, and your trust sometimes lasts 20, 30 years. So now the exception is a valuable motorhome or a collection car that's worth $120,000, then I might put it in the trust.
Okay, so I had my minivan for 27 years, so his statistics are a little off. Yeah. Okay.
Go ahead, Red.
Hey, and then we
So-
have somebody in the front. Go ahead.
So does a trust have a tax bracket other than the individual who owns the trust? And in the example of spouses, one dies, there's real estate, and there's an adjusted cost basis to the survivor. How does the trust handle that?
There's a couple questions there to be answered. If you are married, you should own your property in California as community property, and there's a tax advantage for that.
And it shouldn't be in the trust?
And should it be in the trust?
Which,
The house that
well,
they
the
own in
house,
community.
absolutely, the house should be in the trust.
Definitely.
But the point of that hit me was people own property, real property, as joint tenants, and there's a disadvantage tax-wise, maybe, because there's a certain exemption involved there, but it is better in California for husbands and wives where the house is owned by both of them, that it be titled as community property, and that's irrespective of whether it's in the trust or not in the trust.
Okay, question.
Okay, my question is, I do have a trust, and my question is when does the trust need to be amended, or so I've heard different questions depending upon how you want to change it, that you'd have to redo the whole trust, or can you make, for example, if I want to change the amount going to the church maybe, or somebody else, a redistribution of assets, do I have to redo the whole trust, or can I make an amendment to that particular part of the trust?
Yes and no.
Okay, that answered my question.
So I do amendments all the time when it's a minor change. Some people come in, like in the old days when they had AB trusts, which we don't want to have anymore, and it's a tax issue. So then I do an amendment and restatement of the trust. So when you redo your will, you redo your power of attorney, throw away the old one. When you amend your trust or do an amendment and restatement of your trust, never throw away the old one. A trust has a life from its beginning, even though it's amended or changed, until the end. And so you never want to throw away the old docs, because someone may challenge it and say the amendment was invalid and they have to go back to the prior document. The question in the back that I missed was the tax ID number. The social security number for the person, if you have a trust, stays the same. You don't get a new tax ID number for the trust as long as you're alive. It's only when if you're married, the second spouse passes away, or if you're single, you pass away, then a new tax ID number has to be acquired from IRS.
Okay, I think there's a question.
I have a question.
Oh, okay.
Actually, now I have two based on your last answer.
Oh,
First, I wanted to ask, what is the value before probate takes effect? Like, for example, you said if you have a motorhome of maybe 125, put it in the trust, but the vehicle worth 50, not necessarily. Is there a dollar amount that collectively, I understand it's all the assets combined, but
$208,500. Now, don't just go off what I just said. Consult with somebody and get good advice as to what goes into calculating that number. And that number just went up, I think, April of last year. And so it changes periodically. It used to be 166,000, and it's 180. 208,500 is what they call a summary probate. And if that's all you have, you don't have to have a formal probate. But there's also just changed the laws in California as of last April with regard to your primary residence. If it is worth less than $750,000, you do not have to have a full-blown probate. But again, you need to consult with an attorney as to what needs to be done.
And then my secondary question was, you said you don't recommend an AB trust anymore. Can you elaborate a little bit on that?
It has to do with the $15 million estate tax. When you had, when the federal estate tax was much lower, it used to be $1 million. And some of these homes and stuff, and when one spouse died, it would go to the surviving spouse, and you would trigger an estate tax. To avoid that, you did what they called an AB trust, where each spouse was able to leave whatever the exemption amount was to their heirs. Don't worry about it unless you have $15 million.
Okay, so I think we have time for one more question. I'm sorry. We have time for one more question, and then I need these people to wrap it up.
So this is a question from the chat. It's a two-part question. First of all, in terms of hiring a lawyer, how do you know who to trust? And then the second question was, what kind of will do I need to assign who would raise my kids?
Crystal, you're up.
Who to trust? I mean, I think a lot of us determine who to trust based on recommendations from the people that we trust. So asking people in your community for referrals. I think we got shown proof why sometimes reading Google reviews is not going to give you a good idea of who you can trust. I kind of do the tried and true method of going and meeting a few people and seeing who, knows the information. You can ask them questions that you know the answer to, that, hopefully they give you the right answer. You can test people out when you go and see them. You can have consultations. You don't have to hire the first attorney that you meet with. And I think the most important thing is that you deal with somebody that you're personally comfortable with, that you get along with, that seems like they respect you. And for all of us professionals, we don't know everything, so, and you don't have to know everything to be able to help someone effectively. All you have to do is know where to find the answer or know who to ask for the right answer. And I have great colleagues that I consult with, so to get the right answer. So I think the most important thing is who you feel comfortable with, if it's a person that you've been recommended to, and get 2 or 3 consultations and see if there's a person that you like and that you get along with and who respects you.
Okay, then the second question.
Oh, what was the second question?
Sorry. Had to do with a child and guardianship, and how do you assign guardianship?
They wanted to do it through a will, and that's...
No, you really have to have the whole estate plan working together to assign the guardianship for your children. What I do is, in an estate plan, I'll put the guardianship nominations in the will, but you need them to work together. You can't just have a standalone will that does that. You have to have the trust too. One of the important things that the trust will do in that situation is set up a trust for your child. So it's called a health education maintenance and support trust, because obviously, like, you don't want to give a child a lump sum. What are they going to do with it? So you have to give your trustee the power to manage your assets for the child, and the trust will set up that HEMS trust, that health education maintenance and support trust. So they all work together, and then when you do have minor children, your estate plan will also contain a power of attorney for your child's financial decisions, and will also contain a medical power of attorney for your child. So the whole thing works together. You can't really do it on a piecemeal basis, in my opinion.
Got it. So I'm sure there's still a bunch more questions. We've gotten a lot of information to absorb. But what I would like to do, I'd like to end, unfortunately, I'd like you all to do two things for me. If you would tell us what handouts you've brought, and then give us briefly kind of your last words of wisdom. Take a moment, but start with Gary.
So the handouts I brought a statutory will on the back table. I have brought a document that describes the duties of an executor of a will, and I've brought several post. A post is a physician orders for life-sustaining treatment. It replaced the DNR, the do not resuscitate. So a post is what is in the law in California now, today. So you have a power of attorney for health care and a post. The post, again, is signed in front of a physician. The power of attorney for health care is usually notarized. Make sure they are the same, because there are choices that you make under the power of attorney for health care as to, forgive me, but how fast you want to die. Do you want to be made comfortable, or do you want to last until the ever last breath and that you have? So there are also choices in the post. Just make sure that they're consistent. There's a recent case that came down where they weren't, and it caused a lot of problems. Cost. What does it cost to do a will? What does it cost to do a trust? Every attorney is going to be different. I gauged my cost as to the time I think it's going to take me. Usually the will is a fairly standard fee. And when you do a will, you do a power of attorney for financial and health also. But when you do a trust, for example, I had a guy a while back that had 8 oil and gas leases in Oklahoma. It took me 3 days to transfer those to his trust. I didn't make any money on that trust. So the attorney, and I don't know about Crystal, but I gauge what I charge based upon the amount of time I have to spend. The last thing I would like to say is consult with an attorney of your own choosing.
Marilyn?
So my final, I guess, words of wisdom would be, when you're thinking about planning from the cradle to the grave, or if you're somewhere well on that journey, I would just say that make sure that you have properly updated everything. I know there have been instances, I know this happened a couple of times, someone died and they forgot to change the beneficiaries on certain documents. And in a situation like that, that's tied to those unintended consequences. So I would say that if you are on that journey already, or whether you're already in the process of that cradle to grave financial planning, just make sure that you know that this is a holistic journey, and all along the way, you should be just kind of astute about what is going on with that journey. Because all along life's path, there are twists and turns, but it's about your financial assets and what you intend to not only use them for your life, and you want to structure them such that you don't outlive your, I'm sorry, you want to outlive your money. No, wrong. I think you know. I said it in the reverse.
No. You don't want to outlive your money.
You know what I mean.
Yeah.
But I just think that it is important that you take this financial journey seriously and just navigate every facet of that journey as best you can. And definitely seek out the professionals, because that's why we're here. So, and what was the other part to that?
If you left any handouts, but I think you left your business
I
card.
did leave a handout back there, and there is one piece in that handout I think will be very valuable to you if you are a pre-retirement or even if you're already retired, because it speaks to pre-retirees, retirees, people who are already in the process of doing the RAMDs, and there's an age-based guide along that. It's the last page on my handout. So thank you.
Thank you. Crystal?
Thank you so much for having us today. I did not bring any handouts. I put some business cards in the back, but next time I will come with handouts. I've learned something about that today. I think my parting words are like Nike, just do it. There's a lot of mental barriers that come into play, a lot of time barriers, a lot of things we come up with in our heads that allow us to put this kind of stuff off. It doesn't seem urgent. It doesn't feel necessary. But number one, I promise you that when you start the process, you will feel so much better. And when you end it, you'll feel even better. You'll feel 100 times better. You'll feel as if a weight has been lifted off of your shoulders. You'll be doing the people who come after you, be doing them a great service. I think of estate planning as a gift as well. You're giving the people who come after you the gift of having had the foresight to put procedures in place for them not to have to spend extra time, money, heartache, dealing with your stuff, also in the midst of grieving your loss.
Good one. Yeah. Thank you. Marcia, and I apologize to you guys. Really, we were hoping to get more into the planning, but
it's all good.
We'll get you back.
We just appreciate you guys putting this together, all of you that coordinate this. It's so important. It's a really important subject for people's lives. I mean, it's really important. So I did bring these solution pamphlet, and this is age-appropriate tips to introduce financial education to children. And so if you have grandchildren, children, that would be a really good brochure for them. And there's also a little SKU code on there to pull up another. It's actually the one that Tony brought. So if you don't get that, or if we run out, there's a SKU on there for that. And I think final words is just getting a plan together and being patient with the process, because patience and understanding of how people got into situations and how to get through them is the most important thing to the foundation to the financial house. So here's.
Thank you. Tony?
Wonderful. Hey, thank you guys for having me once again. I brought the How Money Works. It's approved for all ages. Just great financial concepts inside. Anyone can use it. If there's going to be something in there valuable for you, there's plenty back there, and if not, there's a box. Feel free to grab them. But yeah, so regardless, whoever you are, if you're planning for investments, financial planning for younger kids, you yourself, during retirement, during the planning phases, during the accumulation phases, or you're planning towards the end, passing on beneficiaries. No matter whoever you are, we're all here to help out. So last words of wisdom, let's do this. Most people don't plan to fail, they just fail to plan.
Yep. Good one. All right, thank you all. Yes, like we said.
Quick comment. One, thank you to our
Was that awesome? Yep.
and thank you for a wonderful and informative session. And thank you to our, I've always been able to project. And thank you to our ABC committee for doing this wonderful, and Claudia, also you, Linda, for all to bring this. Again, before a minister, I was an economist. This may not be the more, to quote my little daughter, the more funner thing in life, but it is so important. It is so critically important. Thank you so much.
And thank you to all our panel. I'm sure you appreciate their information.
It was valuable.